The gavel slammed down, and Judge Howell leaned forward, voice cold and cutting. "Congresswoman Crockett, you will not turn my courtroom into a political theater." The room went dead silent. But Crockett didn't sit down. She lifted her head, locked eyes with the bench, and answered without hesitation. "Your Honor, the Constitution does not end at your bench." In that moment, the air changed, and everyone inside that courtroom knew this was no longer a normal hearing. It was a direct showdown. The courtroom was already tense before a single word was spoken. Judge Howell did not need to raise her voice to dominate a room. She carried authority the moment she walked in. Her reputation came before her, and everyone in that courtroom knew it. Lawyers had learned the hard way that long explanations got cut off, emotional arguments got shut down, and anyone who pushed too far got put in their place. She leaned forward slightly, fingers resting near the gavel, and said flatly, "This court will maintain order. I will not tolerate grandstanding." The message was clear. She controlled the pace, the tone, and the outcome of the room. When she spoke, people usually backed down. That was the system she had built. But Jasmine Crockett did not flinch. She didn't lower her eyes. Instead, she answered back, steady but sharp. "Respectfully, Your Honor, what you call grandstanding is what accountability looks like when people in power would rather not be questioned." A ripple of tension moved through the gallery. Crockett stepped half a pace forward. For years, courts have been comfortable hearing from government lawyers. But the moment someone speaks for the people losing their rights, suddenly it's too political. That double standard is exactly why we're here. The words landed hard. Judge Howell's jaw tightened. The line had been crossed, and everyone knew it. Unlike many attorneys who grew up inside elite political networks, Crockett carried something different into that room. She wasn't polished by private donors or protected by party leadership. She was shaped by overcrowded courtrooms, long nights preparing emergency injunctions, and clients who showed up scared because they didn't know if they would be heard. "I didn't learn constitutional law in a quiet office," Crockett said bluntly. "I learned it standing next to citizens who were denied a ballot, denied housing, denied basic fairness. So forgive me if I don't treat this like an academic exercise." That line drew a visible reaction from the audience. Some nodded. Others held their breath. Crockett shifted the focus directly to the heart of the case. "Let's be honest about what these laws do," she said, her voice growing firmer. "Early voting windows are being cut. Mail-in ballots are being limited. ID rules are being tightened in ways that conveniently hit the same communities every time." She paused and looked straight at the bench. "You can call it security all day long, but when working parents can't make it to the polls, when seniors can't access mail ballots, and when poor voters face extra hurdles, that's not security. That's suppression with a new label." Judge Howell interrupted again, sharper this time. "Counsel, this is not a campaign rally. Stay within the boundaries of legal argument." Crockett didn't sit back. She fired right back. "Your Honor, when laws quietly remove millions of voices from the ballot, pretending that's not political is the real performance." The tension snapped tighter. A few people in the gallery gasped. Crockett pressed forward. "Democracy doesn't die in dramatic speeches. It dies in paperwork, deadlines, and barriers designed to look neutral while targeting real people." She leaned into the microphone slightly. "I represent voters who stand in line for hours. I represent communities that already face obstacles every single day. And now they're being told to accept even more barriers in the name of order. That is not law protecting democracy. That is law being used to shrink it." The room felt heavier with every sentence. Judge Howell raised her hand. She cut in again before Crockett could finish her next sentence. "Counsel, answer the question directly," she snapped. Crockett barely paused. She adjusted the microphone and continued anyway. The judge interrupted again, louder this time, trying to steer the room back under her control. Crockett finally stopped, looked up, and said calmly, "If I'm being cut off every time the facts become uncomfortable, then we're not having a legal hearing. We're having a performance to avoid the truth." A murmur spread across the gallery. The tension thickened. Crockett's tone sharpened. "So let's stop dancing around it. Let's talk about what these laws actually do." She reached down and lifted a set of printed charts, holding them up so the front rows could see. These are turnout projections from independent election analysts, she said. Not activists, not political groups, data. She pointed to the first page. Early voting restrictions alone reduce participation by double digits in urban districts. Then she flipped the page. Mail-in ballot limits hit seniors and disabled voters hardest. Another page followed. Tighter ID rules disproportionately affect minority communities who already face access barriers. Judge Howell waved her hand dismissively. These statistics are not relevant to statutory interpretation, she said. Crockett's response came fast. They are relevant when the outcome of your interpretation silences millions of voters. The judge tried to move on. Crockett didn't let her. Your Honor, I formally request these materials be entered into the court record. The room shifted instantly. Heads turned. Reporters sat up straighter. Judge Howell hesitated for the first time. She looked down at the documents, then back at Crockett. This court is not obligated. Crockett cut in, firm but controlled. This court is obligated to consider evidence that shows constitutional harm. The gallery reacted audibly now. You could hear quiet gasps. Phones came up. The judge paused, clearly weighing her next move. Crockett didn't wait for the tension to cool. She pressed forward with speed and precision. Brown versus Board of Education, she said. The Supreme Court made clear that equal access is not optional. Reynolds versus Sims established that dilution of voter power violates the Constitution. Harper versus Virginia Board of Elections ruled that financial and procedural barriers cannot be used to block citizens from voting. She delivered the cases one after another, fast, sharp, and relentless. Each citation landed like a strike. The courtroom felt smaller with every word. Judge Howell leaned forward, irritation visible on her face. Congresswoman, the judge warned, voice rising, if you continue in this manner, I will consider holding you in contempt. The word hit the room hard. Contempt meant fines, removal, humiliation. The stakes just jumped. Crockett didn't blink. She looked directly at the bench and answered without hesitation. I am presenting precedent, Your Honor. That is my legal obligation. The room went dead quiet again. She continued, slower now, deliberate. What's happening here isn't disorder. It's discomfort. Discomfort with hearing how these laws collide with constitutional protections. She straightened her posture. Threatening contempt doesn't change the law. It doesn't erase Supreme Court rulings. And it doesn't make these constitutional violations disappear. The pressure flipped instantly. Now it was the judge under scrutiny. Crockett had seized control of the narrative, the tempo, and the moral high ground. Just as Judge Howell leaned forward, about to say something, Crockett raised her hand, not timid, not hesitant, high enough that everyone in the room could see it. The movement was simple, but it hit the courtroom like a shockwave. The judge froze mid-sentence. The clerk stopped typing. Even the bailiff shifted his weight. Crockett's voice cut through the silence. Your Honor, before you shut this down again, I need the court to hear this. The room went dead quiet. You could hear someone in the back swallow. Crockett held her hand in the air for another second, letting the tension stretch, letting the moment breathe. She lowered her hand slowly and locked eyes with the bench. Article 1 of the Constitution created the branch of government I serve in, she said. That same Constitution created this judiciary, which means this courtroom does not exist because of tradition or personal authority. It exists because the people gave it power. Judge Howell shifted sharply in her seat. Crockett didn't stop. So when you dismiss constitutional harm as political noise, you're not protecting the law. You're shielding the system from accountability. A low murmur rippled through the gallery. Someone whispered, "Wow." Crockett's tone hardened. A robe does not make anyone untouchable. A gavel does not erase constitutional duty. The silence grew heavier. Crockett took one step forward, just enough to signal she wasn't backing up. You sit on this bench because the Constitution allows it, she said. And that same Constitution binds you. Not me, not the voters. You. Judge Howell's face tightened. Her knuckles whitened around the gavel. Crockett didn't let the judge recover. She delivered the next line like a direct strike. "So let me ask you this, Your Honor," she said, voice steady but cutting. "If constitutional arguments are silenced here in a federal courtroom, where exactly are citizens supposed to go?" The question hit the room like a punch. Crockett kept going. "If people can't challenge voter suppression in this building, then the promise of justice becomes a slogan instead of a right." A reporter gasped out loud. Someone in the front row shook their head in disbelief. Judge Howell opened her mouth to respond, then stopped. She glanced down at her notes, then back up at Crockett. Her voice came out tight. "This court will not be lectured." Crockett cut in immediately. "This court is being reminded of its responsibility." The words landed hard. Crockett pressed deeper. "Because when courts stop listening to constitutional harm, they stop serving the people. And when that happens, legitimacy doesn't fade quietly. It collapses." The room buzzed with tension. Phones were already being raised in the gallery. Everyone sensed the breaking point. Judge Howell's composure finally cracked. She slammed the gavel down with force. "This court will take an immediate recess," she snapped, standing up too quickly. The chair scraped loudly behind her. It wasn't a controlled exit. It was an escape. Gasps erupted. The clerk looked stunned. The bailiff hesitated, unsure what to do first. Crockett remained standing at the podium, calm, steady, unshaken, watching the bench empty in real time. The moment Judge Howell disappeared through the side door, the courthouse detonated with noise. Reporters poured into the hallway, bumping into each other, shouting into phones, firing off breaking alerts before they even reached the elevators. "Federal judge storms out after confrontation," one voice yelled. Another reporter was already live on camera, breathless, saying, "This just turned into one of the most explosive courtroom moments we've seen in years." Outside the courtroom doors, notifications lit up screens across the country. Clips of Crockett's words started trending within minutes. "The Constitution does not end at your bench" was everywhere. TikTok, X, YouTube, cable news chyrons. What had just happened inside one federal courtroom was now a national event. Institutions were forced to respond fast. The American Bar Association released a carefully worded statement emphasizing the importance of hearing constitutional arguments without intimidation. Civil rights organizations moved even faster. The ACLU praised Crockett for defending democratic access under pressure. The NAACP called the confrontation a necessary challenge to judicial overreach. Advocacy groups blasted out fundraising emails with screenshots of the moment, framing it as proof that voting rights were under direct threat. What started as a single hearing had now become fuel for a broader movement. Meanwhile, the damage to Judge Howell's reputation spread quietly but aggressively. Complaints began flooding judicial oversight offices. Legal ethicists posted threads dissecting her conduct line by line. Inside the courthouse, whispers followed her name down the hallways. Other judges avoided eye contact. Some quietly questioned whether she had lost control of the room. Others worried about how the public now viewed the bench itself. While the institution scrambled, Crockett walked back onto Capitol Hill with momentum at her back. In closed-door meetings, staffers whispered about the hearing before she even sat down. During one committee exchange days later, when a witness tried to dodge a constitutional question, Crockett leaned into the microphone and delivered the line that sent another wave through social media. "I already spent an afternoon teaching constitutional law to a federal judge," she said calmly. "You're not going to intimidate me with weak answers." The room went quiet. Lawmakers stared. The power dynamic shifted instantly. The media amplified everything. Her courtroom clip was replayed on nightly news, analyzed by legal commentators, and broken down frame by frame on political podcasts. Universities began using the footage in constitutional law classes. Professors paused lectures to show students what real-time pressure advocacy looked like. Mock trial teams recreated the confrontation. Students quoted her lines in debate competitions. What happened in that courtroom was no longer just a viral moment. It had become a case study, a teaching tool, and a warning shot to anyone who thought Crockett would back down quietly. And through it all, Crockett stayed steady. No victory laps, no dramatic interviews, just controlled confidence and sharper questions in every hearing that followed. The shockwave didn't stop in Washington. Within days, Grassroots organizations across the country felt the impact. Donation pages lit up with traffic. Small dollar contributions poured in from ordinary people who saw themselves in that courtroom moment. Messages flooded campaign inboxes. Thank you for standing up. Finally, someone said it out loud. Activist networks mobilized fast, organizing town halls, voter education drives, and emergency meetings focused on protecting access to the ballot. Crockett's confrontation became a rallying symbol. Her words were printed on posters, shared in group chats, and repeated at protests. What had started as one woman pushing back against a judge turned into a nationwide surge of energy around voting rights. The education world moved just as quickly. Law schools began dissecting the moment in real time. Professors replayed the clip and paused it sentence by sentence, breaking down Crockett's strategy. Calm tone under pressure, precision with precedent, refusal to retreat when authority pushed back. Students started calling it the Crockett method. Mock trial competitions introduced scenarios modeled after the confrontation. Debate teams used her lines as examples of persuasive constitutional argument. In classrooms, the message was clear. This wasn't just drama. This was a blueprint for how to challenge power without losing control. Inside the judiciary, the response was quieter but just as serious. Training programs for judges began adding new modules on courtroom temperament, public perception, and managing high-profile constitutional disputes. Behind closed doors, senior judges warned younger colleagues about letting ego override restraint. The Howell incident became a case study of what happens when authority appears defensive instead of impartial. Nobody wanted to be the next viral clip. Slowly, changes became visible. Judges began choosing their words more carefully. Interruptions became less aggressive. Public rebukes softened in tone. The robe still carried power, but it now carried caution too. Crockett's confrontation had sent a message the system couldn't ignore. Authority works best when it listens. Control only holds when it's balanced with accountability. And for the first time in a long time, the bench itself was being reminded that its power does not exist in isolation. It exists because the Constitution, and the people behind it, allow it to. The moment didn't stay inside America's borders. International media picked it up within hours. Headlines overseas framed it as a snapshot of America's internal struggle. Democracy under pressure, institutions being challenged from within. Political commentators in Europe called it a rare public collision between judicial authority and constitutional activism. Others described it as proof that American democracy wasn't quiet or comfortable, but loud, messy, and constantly tested. Some critics called it instability. Supporters called it transparency. Either way, the world was watching, and the image kept replaying. A congresswoman standing her ground while a federal judge walked away. But inside the United States, the symbolism cut even deeper. To many Americans, this wasn't just Crockett versus Howell. It was grassroots accountability confronting establishment power. It was a civil rights attorney turned lawmaker standing in front of a system that has historically told people like her to stay quiet and stay in line. The parallels were impossible to ignore. People saw echoes of past civil rights battles, moments when ordinary citizens challenged institutions that claimed neutrality but carried unequal weight. Crockett didn't need to say it. The image said it for her. One figure standing firm, one bench left empty. That contrast burned itself into public memory. As the noise faded and the headline slowed, the deeper meaning of that day became clear. This wasn't about winning an argument. It wasn't about embarrassing a judge. It was about redefining who truly owns the Constitution. Crockett didn't treat it like a document reserved for lawyers and courts. She treated it like a living promise that belongs to the people who depend on it. In that courtroom, she didn't just defend voting rights. She challenged the idea that authority gets the final word simply because it holds a title. The final image stayed with everyone who watched it unfold. Crockett walking out of the courtroom, calm, steady, not celebrating, not looking back. Behind her, the judge's bench sat empty. No gavel, no voice, just silence where power used to sit. It wasn't dramatic music or flashing cameras that made it powerful. It was the simplicity of it. One person leaving with principle intact. One institution forced to pause. And that's why this moment still matters. Because in the end, the gavel can command silence. But the Constitution commands history. If this moment moved you, don't let it end here. Subscribe to the channel, stay with this community, and help us keep these stories alive. Share this video, drop your thoughts in the comments, and be part of the conversation that holds power accountable. Because history isn't just something we watch, it's something we build together.